All right, there we go. Welcome, ladies and gentlemen, to Dion's Daily Dose. Today I'm here with my friend Sean.
Hi, everybody.
And we have what I think, anyway, is an extremely interesting case where an offender, convict, there's inmate, there's tons of terms for him, someone serving time, who was convicted of a crime and is now serving time, is attempting to sue the correctional officer or more than one. And it's something that we've seen a lot. I worked at Indiana State Prison for a number of years, and we heard of, I didn't get sued, thankfully, but I know people who did, just for doing their job. And it's an interesting thing that we could get. Like, I could spend hours talking about the ins and outs of that and why it should or shouldn't be a certain way, and all of that. But the way that it sits currently is you're allowed to do that, but only under certain circumstances, right? You have to pursue all other reasonable accommodations or avenues. Yeah, you got to do everything you can before you can get to that point. And this is a little interesting because this attempts to kind of sideline around that and say, well, suing a correctional officer is actually part of all that I can do, basically. So hopefully we'll have a better understanding of exactly the arguments that are being made here as we get into it.
And they go through a lot of precedent and a lot of legal terms through this. Yeah. So we're going to have to try to figure out what they're saying.
Yeah, we'll dig through and get the definitions for you guys. I may or may not be able to have them on screen. We'll see what we can do. Excuse me about that. I'm not sure exactly what we're going to get into. Excuse me, until we get into it. So Sean was kind enough to get the timestamps for us, and we were able to shave it down significantly. So here we go. We're going to get started. And the first person speaking, I believe, is the attorney for the plaintiff. This is what they still call it, right? The plaintiff. Okay. Or petitioner.
You're going to hear Roberts first, and then you'll hear Roberts opens up the case.
Okay. So Roberts opens up the case, and then it's going to go directly into the other one. All right, here we go. I hear nothing. You hear anything?
Yeah, it didn't start yet.
Okay.
It starts at like 14 seconds.
Oh, okay.
We'll hear argument next in case 23-1324, Pertu versus Richards. Ms. Sherman.
Mr. Chief Justice, and may it please the court. Exhaustion is the centerpiece of Congress's reforms under the Prison Litigation Reform Act. Yet even with this invigorated exhaustion requirement, prisoner lawsuits still account for an outsized share of filings in federal district courts.
Yeah.
A rule that requires a jury trial on intertwined exhaustion issues would increase this burden while incentivizing non-exhaustion and undermining the goals and structure of the PLRA. Respondent would have this court cast aside the PLRA's goals and structure merely because exhaustion is an affirmative defense. Focusing on this court's holding in Jones versus Bach, he contends that there's no principled reason for treating PLRA exhaustion differently than other affirmative defenses that are routinely sent to juries when there are facts intertwined with the merits. Jones does not stand for this broad proposition. It held only that prisoners need not plead exhaustion. And there is a principled reason for treating PLRA exhaustion differently than other affirmative defenses. It is a mandatory prerequisite to suit, so its intended benefits would be entirely undercut by merits discovery and a trial before its resolution. PLRA exhaustion must be resolved by a judge at the early stages of litigation. Contrary to the Sixth Circuit, this does not run afoul of the Seventh Amendment, even when there are intertwined facts. The judge's determination on exhaustion does not interfere with the jury's ultimate fact-finding role, because dismissal is typically without prejudice, and the judge's determination on exhaustion would not have preclusive effect. Richards, like many other prisoners, can exhaust, come back, and have a jury decide the merits of any viable claims. For this reason, this court should reverse the Sixth Circuit's decision. I welcome the court's questions.
Okay, so just to make sure, so Sherman is arguing that this should not be the case. Basically, what they're saying, my understanding is that they're saying that there should be a jury trial for every one of these. And the nightmare scenario that would bring, because we're talking about an overburdened court system as it is. As she said, it represents an outsized portion of federal cases. So that's a big deal.
And you don't want to have guards get sued all the time either.
Right. And that gets into a whole other thing because, look, are there some pieces of shit out there? Absolutely. Look, nobody's going to argue that bad correctional officers, bad police don't exist. You know, I'm not going to say that they don't exist because they do. But the majority of people, including correctional officers, are just doing their job. Mm-hmm. And constantly getting sued it's a burden on people. It's already hard to get correctional officers who are good at their job, care about what they're doing, and stick it out. It's, if you guys look into it, correctional officers are actually some of the highest suicide rates out there. Anyway, we're going to jump into our next clip, which is our good old buddy, Clarence Thomas. And I think he has some questions.
Yep.
Here we go.
Are exhaustion determinations normally made by the judge?
They are. And in fact, lower courts are pretty much in agreement that at least when there are no intertwined facts, that judges will make those determinations.
So what is it about the intertwining of facts that changes the nature of exhaustion?
I don't think there's anything that changes the nature of exhaustion. I think what it does is it makes one have to consider the Seventh Amendment now. If there are intertwined facts, is that an implication of the Seventh Amendment? And our position is that it doesn't.
So historically, has there been, do we have any analogs that would suggest that this would go to a jury?
No, in fact, the opposite is true. If the analog suggests that this would go to a judge, we think that the closest analogs, there is no precise analog. There was no exhaustion in 1791. The doctrine hadn't been developed yet. It came as the administrative setting was coming into force. But
she's talking about cases that go way back. I mean, they're relying on precedent here that's been set many, many, many years ago.
And exhaustion is, if I remember right, is making sure that it goes through the right court system. Like can't go straight to the Supreme Court.
Yeah, they have to basically exhaust every level. They have to go to the district
court, the appeals court, and then.
And my understanding of this lawsuit is essentially they want to be able to force a jury trial on every single one of these, which is just bonkers. It's just bonkers.
We know that exhaustion has its roots in equity, and we think that the most, at least appropriate analogs here are equitable defenses, and equitable defenses that would have been, their key characteristic is a deference to another setting.
Sherman, do we really have?
Okay, and then we're going to jump into Jackson has some questions next. Yep. Here we go.
To get into that, I guess what I was a little confused.
Setting.
Sherman, do we really have to get into that? I guess what I was a little confused about from your briefing was that I took you to concede that there's intertwinement here. And if that's the case, we can just assume, I guess, that exhaustion does not entitle you to a jury. That's the part of this that would ordinarily say you don't get a jury, but it's the fact of intertwinement that brings to the fore the question of whether or not the Seventh Amendment has to be satisfied. So,
okay, real brief. What is entwinement? Do you have any idea?
I was wondering that too. I forgot to look it up.
What did I say? Entanglement?
Yeah, entitlement or yeah, entanglement.
Entanglement. Legal. All right, so let's take a look. Oh, it's only the tab, isn't it? Yeah. Okay. So legal context, entanglement can refer to a situation where someone is involved in a complicated or difficult legal matter, lawsuit, delayed by legal entanglements. This is very not helpful. I
wonder if it's like you're being punished for like one crime and then you're trying to sue while you're incarcerated.
That's possible. Another aspect may mean if there are multiple cases, they're tied up together.
That could be too.
Moving on.
We don't really have to worry or think about or rule on whether or not the exhaustion claim gets a jury independent of the other one, right?
I don't think the court has to rule on that. I think it's a question that is naturally embedded in the question presented.
I understand, but if I
obviously-
assume it, okay, so fine. Aren't we still faced with the question that you present as a matter of your question presented is, then we have intertwinement of a claim that does not get a jury, the exhaustion claim, with a claim that does. Do you concede that the First Amendment retaliation claim is one that would ordinarily go to the jury?
When the right to a jury trial accrues and exhaustion has been met, I agree that that is a claim that should go to the jury. And this court has been very clear that 1983 claims are entitled to a jury.
All right, so we do have the intertwinement, at least you conceded in your brief. And so why wouldn't the sort of standard Beacon Theater's view of how we deal with that situation apply here?
Beacon Theaters doesn't apply here for a number of reasons. One, Beacon Theaters was driven by concern for collateral estoppel. Would there be a preclusive effect that would completely cut off any right to have the jury trial on the merits?
I don't see that in the opinion. I mean, I see that it talks about preclusive effect, but that didn't necessarily seem to me to be driving the analysis. And we've had a lot of cases that have applied this sort of intertwinement principle in which preclusion really hasn't been the main focus.
Okay, intertwinement. That's what it was, not entanglement. Okay, so they're talking about Beacon Theaters. Okay, Beacon Theaters Inc. versus Westover is a case in which the court held that the Seventh Amendment guaranteed a right to trial by jury in cases involving both matters of fact and matters of law. So even for civil trials is what they're saying.
Okay.
Now that's really important because that's what kind of trial we're talking about when you sue someone in this fashion, right? You're a prisoner in Department of Corrections for whatever reason you believe a correctional officer contributed to your condition, did something wrong to you, whatever. It's a civil case. It's a civil trial. They're saying that jury trial applies to that based on the Beacon Theaters Inc. versus Westover, which is from 1959.
Wow.
So we're talking about a lot of precedent here and a lot of things that go way back. So we're going to go another approximately a minute and a half with Judge Jackson, and then we'll be moving on.
I think Beacon Theaters itself talked about preclusive effect, and that being a concern. And later on, this court in Park Lane Hosiery said, when we looked at Beacon Theaters, which again, this court has said is collateral estoppel is only a flexible judge-made doctrine. And this court said in Park Lane Hosiery, the concern was collateral estoppel.
All right, so why isn't that a case here? I mean, what law do we have that says that an exhaustion determination by a judge in this situation that requires them to find all the facts about whether or not there was actual retaliation, why isn't that preclusive of a later jury trial related to that same issue?
But what we have here is the flexible doctrine of collateral estoppel. And what we know about collateral estoppel and why it's applied and why it doesn't.
Collateral, what is she saying? Collateral estoppel?
Yeah.
That's what it sounds like to me. Let me see if I can find what that is. Collateral. I know what collateral is. Estoppel. Hold on. Okay. So it popped out. It says here collateral estoppel, also known as issue preclusion. You know what we're going to do? Hang on. Let me drag this over here. Give me 1 second. I'm going to fix this for you guys so that it's doing it correctly. Hold on. Because I want to show you guys what we find. Okay. So collateral estoppel, also known as issue preclusion, prevents parties from relitigating issues that have already been decided in a prior lawsuit, even if the subsequent lawsuit involves a different claim. So that's actually a really interesting point that she brought up from Jackson, no less. She's talking about this collateral estoppel. What does that mean? So when you sue a correctional officer, for example, who knows what other cases you're still mixed up in? You could conceivably say that damage to you has affected multiple cases. Now all these are collateral, intertwined. That's what she was talking about before. When you have multiple cases kind of intertwined, at least that's my interpretation of it.
I think so. Yeah.
What do you think?
Yeah.
And then the estoppel. I keep wanting to say like stoffel, like the what is a badger, honey badger that keeps escaping from the enclosure. If you guys know who Stoffel is? No, look him up. Stoffel, you'll find him. Collateral estoppel. Once something's decided, even if it's a different claim, the lawsuit is over. So
Was that something from a long time ago?
let's see. Where does collateral estoppel originate from? Let's see here. Blah, 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 blah. Oh, that's a trash. Let's see here.
It's
Issue
probably been
preclusion is the modern terminology for it.
It's probably been around.
Yeah, it looks like it's been around for a while. All right. I lost my mouse. There it is. All right. Let's see here. Getting back to it. We got like 30 more seconds.
Get applied. And one of the big issues here is that you don't, this court has said over and over in cases, and so have the lower courts, that collateral estoppel is not applied when the litigants have not had a full and fair opportunity to litigate. And when a litigant is either side is litigating exhaustion, they have not had a full and fair opportunity to litigate on the merits, even if there are overlapping facts.
Why?
General,
Okay. I think I get what's going on so far, and there's some interesting points being raised. We jump next to Sotomayor, who...
Got about a minute. 15.
Yeah, it looks like about a minute or so, and then we'll skip ahead.
Just sort of my
Why? If we take your starting proposition that exhaustion is a judge determination, and you've had a full and fair opportunity to litigate it, why wouldn't that, if it's interwound with the merits, why wouldn't you be bound by it? So you go back later, and you get exhausted and you come back to court on your substantive decision, like you're arguing should be done here. Why wouldn't you be bound?
There may be factual overlap, and we concede that there's intertwinement of the facts.
Assume it's intertwined. I
Yes, it is.
assume everything you say. Our normal preclusion rules would say, if you've had a fair and full opportunity to litigate a case, doesn't mean before a jury. It just means if you were entitled to litigate this issue and you had a full and fair opportunity to litigate it, and you lost on this issue, then you go back and you exhaust and you come back again at the new trial, you would be collaterally estopped.
Okay. So I believe what she's saying, and neither Sean nor I, as an attorney, we
No.
have no legal training. We're just laymen like you. So we're doing our best here. That said, I think I got a pretty good handle on what she's saying, which is if you do go and exhaust like they want you to, then wouldn't you be blocked by this collateral estoppel, I guess, doctrine or common law thing? Is that what you took away, or am I misinterpreting?
Yeah, I think that I'm
Sean's
my
like,
guess
whatever
too.
you say, dude. This stuff's kind of
complicated.
complicated. It is. And, you know, unfortunately, this is something that has the potential to send shockwaves
Yeah.
throughout our entire prison system. If this, when they hand the decisions down for this, it could potentially be, oh yeah, every single one is entitled to a jury trial and exhaustion no longer applies. And, you know, if they wanted to get buck wild, which I hope they don't, because that would create such a backlog in the system, it would be ungodly.
And also, in most cases, you kind of know how each justice is going to vote. But on this one, it could go. I think we're going to see a different combination of people.
Okay.
voting
So
on
you
this
think
one.
we might see a departure from the standard
On this one,
conservatives versus liberal
yeah.
judges?
And Roberts and Barrett will be really interested.
They
to watch on this
will
one.
be. They will be. All right. So we're going to jump ahead about a minute. We're going to do 9:56 to 12:04.
And with those two, you never know how they're going to.
That ain't that the truth. All right. So 9:56 to 12:04. We're going to hear some more from Sotomayor.
Okay. Go ahead.
Can I go back to the floodgates argument? The Second Circuit hasn't had a decision like this circuit, but it has said so in dicta, and the district courts have followed that dicta, basically. And I've gone back.
Victa?
Victa, yeah.
What does Victa mean? Do you guys know? Let's see.
I have no idea.
VICTA.
Yeah.
It looks like a lawnmower. Hang on.
Oh,
Victa. Okay. In legal context, likely a misspelling or a variant of the Latin word victus, meaning conquered, vanquished, subdued, or defeated. Not a standard legal term itself, might be used in a legal concept to describe a similar legal context to describe a similar concept. I was looking to see, here it is. Victimless crime in American English, a legal offense like prostitution or gambling to which all participating parties have consented. Victa. Okay. Not entirely sure how that applies in this context. Let's back it up just a little bit and see.
And the district courts have followed that dicta, basically. And I've gone back.
I don't know how it applies in that context unless she's using it to mean precedent, I guess.
that's what I'm thinking.
Which let's just assume for the moment.
That's what I think
yeah,
she means.
go along with it.
12 years and had our library and my clerk search Second Circuit opinions. And in those 12 years, only 5 cases has there been a litigation over whether or not there was exhaustion. Because only 5 cases was it interwound with the merits. I don't see where the floodgates have come up. And if any circuit has pro se litigation, it's this one. And I also look at all of the other barriers to litigation. You have screening that has to go on. The defendant has to raise an exhaustion defense. The plaintiff has to counter that exhaustion was unavailable. The complaint survives any motion to dismiss, and that you have a genuine dispute of material fact unrelated to exhaustion to justify. I don't understand the floodgates argument.
I appreciate all the steps that you have talked about, Justice Sotomayor.
I didn't
But
make them up. They came up from an amicus that pointed them out.
Yes, but our Michigan data reflects something a little bit different than the data that you have attempted to collect. Last year alone, Michigan had 574 cases that were opened. In 96 of those, we filed motions for summary judgment.
What kind of
For-
case? I'm sorry.
Okay, so she's talking about saying just in Michigan, there were hundreds of these cases. If, for example, and I think this is her point, if you were to demand a jury trial for each of these from the start, imagine the backlog in the system. Rather than letting these judges go, okay, there's no evidence here, for example, or whatever. Go ahead.
That's how it should be. Is
Yeah.
that every judge should decide if it's worthy of a jury trial.
So, and that does open up another can of worms, because that's the way that it currently is. That they basically have to exhaust all the options before they can get to the stage where it's a jury trial. It's in most circumstances, including Indiana State Prison. Just so you guys know, correctional officers do not have qualified immunity, which means they can be sued at any time and have been, but in general, they work their way through the courts, much like they're talking about. There has to be certain rules. They have to go to a panel where the panel looks at it and goes, yeah, there's evidence, or no, there's not. And then to the other district, whatever. I won't pretend to know the whole process. I'm not even going to Google it because it's complicated. But short circuiting it would certainly end up with some real. And then if you do that, if you go, okay, every single one has to go to jury, I guarantee you some of these states are going to start putting in qualified immunity for correctional officers, and just to temper down the sheer volume of lawsuits. That's my prediction. But all right, we're going to jump ahead to Alito's questioning, and that starts at 1424. I don't know if you guys saw, I got my new hat. Came in. Look at that. Right. I dig it.
Yep.
There we go. There, you guys can see it. All right. And this is going to go 1424 to 1557. So about 3 minutes.
Ask you this quick question. Under the Prison Rape Elimination Act and your policy, could Mr. Richards go back and now exhaust administrative remedies?
Absolutely. There are no time constraints for him for any prisoner across the country that has a Prison Rape Elimination Act grievance. There are no time
So
constraints.
why in this case should we be concerned about intertwinement? If exhaustion is decided by the judge says you didn't exhaust, the prisoner can go back and exhaust, and then the prisoner can come back to court, and if can get by summary judgment, can have a jury trial.
Well,
So
there's
I don't get it.
there still is a question with intertwinement here, whether even for the prisoner that can come back, like Mr. Richards, is there a problem with collateral estoppel? Does it violate
No,
a
it's
right
not
to
a
jury?
judgment, and it's a flexible doctrine, and I think every court of appeals but one has said this is a matter for the judge. And what have they said about collateral estoppel? Haven't they said that that the determination that there was no exhaustion would not carry over, would not have an effect on the trial of the merits?
I agree. Collateral estoppel is not a bar here, but that's the reason why it's important to consider this. And that's why I believe this court.
Ms. Sherman, would
Okay. So it's an interesting argument. We're going to jump next to Jackson, which
Goes right into it.
yeah, we go right into it. And this is about 2.5 minutes from 1558 right now to 1837. Here we go.
the same judge who made a determination in the exhaustion realm related to the facts of whether or not this person exhausted be presiding over the subsequent trial in which those same questions about what happened go to the jury?
I don't think there's any rule that would require that the same judge hear that. It could go to any judge.
I'm just asking you as a matter of practice. Don't judges ordinarily keep the case? So you have a judge originally, and I guess I'm just sort of musing about Justice Alito's question of what's the harm. I would think that if the concern in Beacon Theaters and in other cases in which the Seventh Amendment right is fronted is that people really have the right to a jury deciding these questions. And once you've had a judge decide it, we have intertwinement, it's the same set of factual issues. I wonder whether there wouldn't be a burden on your right to make your presentation to the jury, especially if the same judge has prejudged those facts because they had the essential hearing and heard all the evidence and whatnot and ruled themselves as to whether or not they think this happened in this way.
Two responses. This is a dismissal, and whether it's typically without prejudice, but that doesn't mean that that's going to come back to the same judge. It's not the same case. They're going to refile a federal lawsuit. So I don't think there's any reason to think that that's going to come back to the same judge. I don't think it matters either way, because the key here, and this is to my second point, is that there wouldn't be any preclusive effect. So would Richards
not by the judgment,
back,
not by the judgment, but you appreciate that what I'm suggesting, that if it was the same judge who is presiding then over a subsequent trial about an issue of fact that he or she has already decided because they heard the testimony before, they went through the record, they said, no, Mr. Richards, Officer Pertut did not do X, Y, and Z. And then Mr. Richards goes and exhausts and says, now I'd like my jury trial on that same question. One might be concerned, at least, that it would be difficult for Mr. Richards to present his case to the jury with the same judge presiding.
I don't think there's.
Okay, that's actually an interesting argument. So what she's basically saying is, at least to me, again, is that if you go in front of this judge and this judge rules, basically you have no evidence and all this is garbage, for example, and then it makes its way around him, and then it's decided, yeah, you do have a hearing. You go in front of the same judge that basically said all your evidence was bunk. I can see how that would kind of fall under bias. So I see what she's asking. I wonder how much of an issue that is. But like she said, like when you're filing in federal court, there's supposed to be a sequence of judges, which we're having an issue with right now with the White House. We're not going to dig into that, but
and they're going to have a hearing about that next week.
Yeah. Because it's supposed, how do the cases get picked? That's something that we little bitty peons don't get to know.
It's supposed to be random.
It's supposed to be random,
but I don't believe it.
Yeah. It's getting kind of hard to believe that it's a random system when you have multiple in a row picked up by the same judge.
We'll do a show on that.
Oh yeah. Okay. So we're going to move forward to Gorsuch
at 1914.
Where is it at? There he is. All right. 1914. And we're going to take that to 2214. So it'll be a minute. Here we go.
That Richards would then need for his First Amendment.
Ms. Sherman,
here we go.
Who bears the burden on the question of whether the Seventh Amendment attaches?
What's the standard?
Who bears the burden of showing?
Oh, it's absolutely the defendant's burden. It's an affirmative defense.
That strikes me as odd. Wright and Miller, for example, says in cases of doubt, you presume the jury, and it's really incumbent upon those who would displace the jury and say the Seventh Amendment doesn't attach, but the default rule is that you have a right to a trial by jury. Do you have any authority for the contrary?
I
didn't see it in your briefs.
I think what the authority is for the Seventh Amendment not to attach here is that there's no.
Who bears the burden of showing I would have thought you would have borne the burden of showing the Seventh Amendment doesn't attach to a suit at law.
I think that the burden.
I mean, isn't the default rule in this country you have a right to trial by jury?
That is the default rule.
Okay.
Yeah.
And that's a fair point. And we can talk about how much it would overburden the system all day and twice on Sundays. But ultimately, the United States Constitution is pretty damn clear on this point, is that whenever charges are brought against you, whenever an accusation is made, you have the right to face your accuser, and you are guaranteed a right to a trial by jury of your peers for civil and criminal.
Yeah.
So aren't we violating the Constitution every time a judge reviews this stuff? I mean, I don't know. I like I said, I'm no legal scholar.
No, I'm not either.
But at the same time, I go, yeah, that would overburden the system. I'm also a very strong believer in the Constitution, and the Constitution is pretty clear on this. So do we overburden the system, and do we go, you know what? Open the floodgates, let it happen, because we're going to have to deal with this eventually.
Even if they're not if they're bogus, though.
And
But
that's the
problem
thing.
is, how do you know what's bogus and what's not?
Right.
too?
And that's why they set up with the exhaustion rule. You have to exhaust all other options before you're able to do this. That's why so many prisons introduce the grievance system. You can file a grievance. Right here. Here's a grievance form. That's basically personal internal paperwork that goes, this sucks, fix it.
But also you can make the point that it settles it if a judge sees the case and decides that it's bogus.
So yeah, that's another good point. But as we're seeing also with the White House case and with the New York case and with these other things involving Trump, some of these judges are corrupt as hell.
Fair
So
point.
do we let the judges continue to make decisions on our behalf, or do we demand to be heard by our peers for everything, even minor inconveniences?
But you don't want the system to completely be overloaded, though.
So
too.
it's a very fair point. And that's what they're trying to decide. I think it's a hell of a thing. I mean,
It's going to be interesting.
it has a lot of potential repercussions, guys. That's what I'm saying. Like these things potentially could lead to a massive, massive ripple effect. All right, here we go.
The claim accrues. And so, before the claim accrues, I don't think that defendant.
Well, we have a
has-
claim. The claim is here. Now, the case has begun. And once the case begins, I would have thought that you would have an assumption, subject to background rules. There are lots of exceptions, but generally you have a right to a trial by jury. If you have some contrary authority for that, I'd like to know what it is.
And you know what? That's a hell of a question. Constitution says this. What alternate authority do you present that says, no, it's not needed? Let's see what she has to say.
The contrary authority is that this is
Authority. That means a case.
Well-
That means a statute. That means a piece of history saying
Yes.
that the burden is on the defendant rather than you.
I don't have a, well, I think.
I'm not aware of one either.
No, I don't have one, but I think two
Okay, so
pieces of authority.
let me just put a pin in it there, because then we have cases like Beacon. We have cases like Land versus Dollar. We have cases like Smithers versus Smith, where there are jurisdictional issues or sovereign immunity issues, right? Mounts in controversy, and intertwined. Again, the default rule is jury. That's, and I just wonder. Now, Congress maybe it has the power to displace that. Maybe. Question mark. Maybe, right? But if the default rule through history has always been intertwined issues go to the jury, and we have a lot of cases. Why shouldn't we, at least as a matter of constitutional avoidance, perhaps, or statutory interpretation, perhaps, read this statute to conform with those normal background principles, absent some contrary evidence from you?
I think it is the nature of the unique nature of PLRA exhaustion. And
I don't think she knows.
No.
Like, I genuinely, I hear her trying, but you can tell she didn't expect that question.
No, she did not.
Which is interesting. All right. We're going to jump ahead a little bit
The
to
Sotomayor.
2305. And this is Justice Sotomayor, who also has some interesting questions. Here we go.
It's
In
not a
order to-
prerequisite to suit. We called it an affirmative defense. The defendant, the
Yes,
plaintiff doesn't even have to allege it. So it's not a prerequisite to suit. It's an affirmative defense. And I don't know of any other affirmative defense that we've said isn't subject. And I think this is
sovereign immunity. Yeah.
a sovereign immunity is an affirmative.
Okay, hold on. Affirmative defense, right? Let's see what this has to say.
There it is.
Legal defense where the defendant admits to the facts of the case but presents new facts or arguments that, if proven, would negate liability or reduce the claim, even if the plaintiff's initial allegations are true. An affirmative defense is something like self-defense, where you admit, yes, I hurt that individual, but the reason that I hurt that individual is because they were attempting to hurt me or my family. That's an affirmative defense. That means, yeah, I did what you're claiming I did, but the reason that I did it provides me with some degree of legal immunity or protection.
Affirmative defense. And we require to go to
And
sovereign
what was the other
that
thing?
we've said isn't subject. And I think this is
Sovereign immunity. Yeah.
a sovereign.
Sovereign immunity.
That's probably similar.
Protects a sovereign body like the federal or state government from being sued without
Oh.
its consent, meaning it cannot be held liable for civil wrongs committed by its departments, agencies, or employees unless the sovereign body expressly grants permission to be sued. That's some of the stupidest crap I've ever seen in my life.
Like, who would be, yes,
How
please
the
sue
heck-
me. Please sue me.
Right? The doctrine is rooted in the common law principle that the king could do no wrong. The federal government cannot be sued without its consent, and any waiver of immunity must come from an act of Congress. So, in order to sue the federal government itself, what?
I guess you have to ask their permission.
State sovereign immunity. States are immune from lawsuits in federal court, and the 11th Amendment further reinforces this protections. Okay, I think it's saying that the federal government cannot be sued by state governments,
I think that's what it is.
and the state governments are immune to lawsuits in federal court. So the Federal Tort Claims Act, FTCA, is an example of a federal law that waives the government's sovereign immunity, allowing citizens to sue the United States for certain torts committed by federal employees. Either way, our government should have no immunity against citizen lawsuits. Like, that should go without saying. We're supposed to be in charge of our government. How the hell are we not allowed to sue our government? Anyway, we're going to move on.
Sovereign immunity is an affirmative defense, and we require to go to a jury.
this court said in Porter versus Nussel that PLRA exhaustion was a prerequisite to suit. That is the term.
But when we got to the issue in Jonas, we said it's an affirmative defense.
It's affirmative defense. It doesn't change the fact that it is a prerequisite to
So
suit.
whatever it is.
Okay. They're going to go back and forth for a bit on whether it's affirmative defense or any of that. But Kagan is our next one. And I think
And
she's
goes right
actually
into it.
breaking in right here to tell us that. Here we go.
Is, right? You have conceded,
The fact that it is a prerequisite to
so
suit.
whatever it is,
Whatever it
right?
is.
You have conceded that it's completely intertwined with the merits in this case, correct?
One correction, we have conceded that it's intertwined. I don't concede that it's completely intertwined.
Okay, well, let's just
Very
take an example, which is a prisoner says he tore up my grievance papers. And that is the claim. You know, that's it's also the exhaustion question, right? Because if he tore up his grievance papers, then the grievance process wasn't available to him. So that.
Okay, now that is an interesting claim. Why? Because as we talked about earlier, there's a certain level of exhaustion that has to be done. The prisoners start with a grievance form. They'll fill out a grievance form. Basically, it says, what's your problem? And they say the problem. And then they'll generally send it to captain, lieutenant, case manager, caseworker, whatever, another individual so that they can bump it up. Or they can send it to the administration and say, hey, this officer did whatever to me. Now, if this officer did indeed tear up his grievance form in front of him, then the case can be made. He attempted to do exhaustion, but it was denied to him, which I think is what she's saying now.
That's the nature of the exhaustion question. But it's as well the nature of the substantive claim that he tore up my grievance papers and in some kind of retaliatory act, right? So let's say that. Completely intertwined?
No.
No?
No,
Why?
there is an intertwining of the fact of whether the somebody at the prison facility tore up the
Okay,
grievance.
so
That's the intertwining.
that's good enough for me.
Okay.
So in the question of exhaustion is going to depend on somebody's finding of whether the warden tore up his grievance papers. And similarly on the merits, it's going to depend on somebody's finding of whether the warden tore up his grievance papers.
That is the overlapping fact, but exhaustion is also going to look at what was the grievance process, what was the system set up, were there other
I don't really
avenues?
think so, General. I mean, I think if like the warden tears up your grievance papers, somebody is going to say that the exhaustion process wasn't available in the way it should be, according to Ross v. Blake. So in the end,
Hard
the
to argue
same
with that one.
fact is going to be dispositive as to both these issues. And let's just stipulate that in some cases that might be, and that's the cases that we're talking about here. And so then I think that the question that Justice Gorsuch, for example, was asking is, okay, when that is the fact, that's the crucial fact, whether it's Beacon Theaters, whether it's Beacon Theaters plus the default rule of the Seventh Amendment, it should be the jury that decides that question, shouldn't it?
And the jury would be deciding that question here because the jury, when Richards comes back, the jury is going to.
But you see, first you have to convince the judge of the exact same fact, because if you can't convince the judge, you can't get to the jury. And so that seems as though, well, if you have to convince the judge before you get to the jury right doesn't mean all that much.
I disagree because even Moore's federal practice has said when there is a resolution of a preliminary matter, for example, something like exhaustion, it's not a merits decision. It's not, you are not deciding the merits.
So that seems right as a general matter because the questions of fact are not so intertwined as a general matter. But where they are so intertwined, so that the question of fact that you're asking the judge to decide is essentially the same as the question of fact that you're asking the jury to decide, in that context, which won't be every context, but in that context, to say that you have to convince the judge that you're right before you get to the jury seems kind of like a flipping of the usual default rule that Justice Gorsuch was talking about.
That's, I mean, hard to argue. Doesn't forcing something to go in front of a judge derail your right to a jury trial, especially if you have some crazy judge that isn't ruling based on actual law, but whatever agenda they have? That's going to create a problem. Let's see.
Convincing the judge of exhaustion, and then because what saves the day is that collateral estoppel wouldn't apply, and so when you're coming back, the jury is fully acting as the fact finder in that case.
I mean, I'm torn.
This is a hard.
This is going to be a tough one. I'm hearing questions from like people that I wouldn't expect to ask these questions. So This is actually quite interesting.
You see what I'm saying with that? I think it's going to be
Oh yeah, I think we're gonna have some surprises
Uh-huh.
on who votes what.
And
It's gonna be
Roberts will wait
interesting.
until everybody votes, and then he'll decide
Yeah,
to
then
vote.
he'll
He always
decide the
does
way
that.
he does. Right. Okay, so we're gonna go right into it, and it should be our buddy who was just here last week. I'm kidding, Justice Thomas.
Thank you, counsel. Justice Thomas?
This was dismissed without prejudice.
You're not done. Sorry.
I'm sorry.
Oh yeah, she
This
tried to
was,
leave.
She tried to
dismissed
walk
without
away.
prejudice.
Bye.
Yes.
So what preclusive effect would that have?
Well, it would have no preclusive effect. Mr. Richards can come back, and he can come back. He still has to convince a judge that he has exhausted. And then when it gets to a jury, there would be no preclusive effect.
And he would have a complete trial on whether or not his filings were destroyed or his grievances torn up.
In part, I mean, he would have a trial, a full trial on his First Amendment claim.
Exactly.
And that would include not just whether a grievance was torn up or he was threatened, but the reasons for that, the motives, that there would be a more extensive inquiry appropriate to the First Amendment.
Okay.
I think it goes right into, doesn't it?
Yeah, we're going right into Alito. There we go.
Justice Alito?
On this issue of the default rule, I thought the Seventh Amendment was limited to suits at common law and therefore applies only if a particular claim is a claim that could have been asserted at common law or is a close analog to a claim that could be asserted at common law. So in light of that, I don't know why I don't know where this idea that there's a default rule in favor of jury trial with respect to every claim for damages, every new claim at law that Congress may create. Am I wrong?
I agree that there is no right to a jury trial here on exhaustion. And the reason is it didn't exist in 1791. The closest analogs we have are equitable defenses that would have been heard by judges and not by juries.
Thank you.
Okay. Did she just argue that because we didn't have it set up for juries in prior to 1800 that it should stay that way?
Didn't she just do the other side of the argument too, like for her case?
That's what I thought. Like between the two things that she said, I'm a little uncertain as to where she was headed with that. But okay.
I'm not.
Yeah, again, we don't pretend to be lawyers. We don't even play one on TV. But we're going to go right into Sotomayor.
Justice Sotomayor?
Counsel, if we limited the rule to your situation, meaning he's not precluded because he can come back because of the law that Justice Alito pointed to, the rape law, I'm not sure that's true because is he alleging rape or is he alleging First Amendment?
And the law they're talking about is PREA, Prison Rape Elimination Act. And it changed a whole bunch of stuff. I can't even get into it, but it changed a whole bunch of the stuff, the way that certain liabilities fall. And it was basically designed to attempt to clean up what had become a vicious and dangerous prison system.
Did that happen during the Obama administration?
I'm not sure when PREA was passed.
I think it was
Let's
Obama.
see. Let's find out.
Yeah, that would be interesting.
2003.
So it was under George W. Bush.
Yeah, it was W. And it's a lot. It goes into a lot, but that gives you guys, if you want to look it up, by all means, it's quite detailed and complex.
Violation.
Under the Prison Rape Elimination Act, First Amendment retaliation for claims of sexual abuse are included.
So that's
in.
but what happens to the ordinary prisoner? If we announce the rule that you want us to announce, which is exhaustion never goes to a jury. In the mine run of cases that are not rape related, prisoners are precluded, practically speaking. We have an amicus brief that says that most exhaustion requirements are, half of them, half the states, are 15 days or less. And in the others, they are matters of days more than that, but no more than 30. Most of the time when you file a suit as a prisoner, it takes, the answer takes 30 days.
Yeah.
Wow.
So most cases, as a practical matter, would be precluded if we adopt your rule that exhaustion under all circumstances is not preclusive.
I don't agree that in most cases the prisoner would not be able to return. I agree that the time
Why
frames
not?
for grievances are very short because
So if they're very short, seems to me, as a practical matter, I can't see how almost any prisoner could go back.
you have 31 states, the District of Columbia, and the Federal Bureau of Prisons, all that allow for some level of discretion to excuse untimeliness. And
Wait a minute, that depends on you, meaning the prison. Why would a prison ever do it? Are you aware of any prison that says you failed to exhaust, but now you can come back?
the reason I assume that when they put it, they don't have to put it in their policy. So if they put it in their policy, I assume that that's important to them.
This is
And-
news to me that there is any state that says if you go to court, they say you failed to exhaust after a factual finding, that we're now going to let you come back to court after you've brought it back to us. Does your state do that?
Yes. Yes, we have a provision, and there are many states that have provisions.
I'd like you, I asked the court to have you give us examples of that situation occurring.
I can't provide those examples.
You
I
can't
don't
because
know.
I haven't found one.
Oh,
The policy
Well,
is discretionary.
That's why she wanted
This policy is discretionary, and the reason that a prison system would want to do that is because everything in the PLRA is designed to encourage, to allow the prison system to work out their problems, and they do want to work
Counsel,
those out.
what you are proposing to me is that they have an exhaustion requirement that they're willing to excuse every time a prisoner goes to court. The court says you failed to exhaust, and now the prison is going to say, come back and we'll let you exhaust now anyway.
right. That's come on, Brad. Like, come on. Like, everybody knows that's not going to happen.
I don't think Sotomayor is buying her.
No,
case.
she's not. That's the thing. You can tell Sotomayor is like, yeah, show me an example, right? Any example.
Yeah.
You know, she's like, well, I can't. I know, because I haven't found one yet.
Yeah.
Yeah, she don't play.
She doesn't.
It will depend on the circumstances. And a lot of these policies say they're extenuating circumstances or good cause, just cause.
It begs the question that a judge has found that the prison guard didn't stop you from exhausting, and now the state is going to permit you to come back and try again.
I think it is in the best interest of the prison systems to try to work out problems. And one of the things that our amicus, multi-state amicus brief led by Ohio has pointed out.
I'm going to pause it really briefly here, just because one of the things that we've seen in the prison system, and I'm speaking from personal experience here, is there seems to be a serious lack now of getting to ultimate accountability for the bad apples, right? Whether that is food service, whether that is medical, or whether that is really, really power hungry or crazy correctional officers, because they do exist. With the PREA and with the changes that were made, the grievance system and all that other stuff was installed. And I wonder if by doing that, if having, all of this and having to go through the prison first before you can, do you think that people's rights are being violated and that no recourse is available to them?
I don't know. I really hope not.
I hope not too, but I mean, we can, hope, but
It
who
probably
really
does
knows?
happen.
What do you guys think? Let us know in the comments.
It probably does happen.
I mean, I'm sure it does. I'm sure it does, because when you're locked in a cell, you have very limited ways of interacting with the outside world, even your attorney. Legal stuff is supposed to be off limits, but who's to stop these people? Just saying.
Is that under Mr. Richards' rule, if this court adopts it, there are going to be very few prison systems that want to allow for any excusal of untimeliness. That's going to be a disincentive for them to do that because they've already gone through a jury trial. Now, why are they going to excuse untimeliness? But if a prisoner can go back and under certain circumstances, they're the discretion.
I'm a little lost. They've gone through a jury trial, they won, and the prison is going to listen to the complaint again?
No,
Right.
if they have a jury trial and they've won,
Why would they bother?
Right.
Why would the state bother want to?
it's
What
if
incentive
there's a
does it need to?
dismissal for failure to exhaust without prejudice. The question is whether Richard's rule incentivizes any kind of discretion.
All right, thank you,
If the
counsel.
judge is deciding it, yes. If
We're
a
on
jury, no.
different pages.
Yeah.
Yeah. Yeah.
I think
It's
she
like,
was tired of talking to her.
yeah. I got the distinct impression that she's like, okay, I'm done with you. Unless I hear something crazy, I know what I'm going to decide.
Now it's time for the other side.
Now it's time for the other side, which is the lawyer for the inmate who originally sued. I do believe because this individual, Pretu, is the officer.
Okay.
I believe. Or maybe
I
it's,
think
or excuse
Richards
me.
is the officer.
I'm sorry.
I think
I think Pretu. Let's find out because we're going to start at 4609. The reason I say that is because Ann Sherman was arguing for no jury trials.
Okay, so you might be right.
So, but let's see.
I could be mistaken.
Yeah, it's mistakes may or may not happen. Let's see here. Okay, so we're jumping ahead to 4609. And we're going to hear from, I believe, Lori McGill, which is the attorney for the
That's
other
not
side.
true with exhaustion.
Thank you, counsel.
All right, here we go.
Ms. McGill?
McGill.
Thank you, Mr. Chief Justice, and may it please the court. I just wanted to begin with two clarifying points. This is the first time in this 5 years of litigation that the state has represented that all of the claims might be able to be exhausted. The First Amendment claim that was the subject of the Sixth Circuit's decision here, as far as we can tell, is not protected by the PREA policy. And the Sixth Circuit held that exhaustion and the merits here were completely coterminous under Sixth Circuit First Amendment law. The state also agrees that the historical facts at issue here are of the type that juries decide. And I think that makes this an easy case on the actual question presented, because whatever else is true, this is a 1983 action for money damages. So the jury must resolve those facts regardless of how you characterize exhaustion. That is the point of Beacon Theaters, which is just a specific application of the general rule that even truly threshold issues must be deferred to the jury when they're intertwined with the merits. It's no answer to say that the facts could be relitigated in front of a jury, maybe, if and only if the case proceeds. It's simply not good enough that the jury trial right might sometimes be preserved. And the state's suggestion that judicial findings would not be binding on a future hypothetical fact finder really gives the game away. The only reason that would be so is because of the Seventh Amendment. That was this court's unanimous holding in Lytle, and there's certainly nothing in the statute or the federal rules that would suggest the non-binding factual findings procedure that the state suggests here. The state warns that having jury trials on exhaustion will undermine the goals of the PLRA. Those very same arguments were presented and rejected in Jones, and they're even less persuasive here. The state's approach would not reduce the number of trials required. We're talking about the cases that have survived judicial screening and Rule 56, the needles in the haystack, as it were. Regardless, policy arguments are no match for the Bill of Rights.
Pretty compelling. I mean, she's basically arguing what the other one was trying to derail, which is it's pretty laid out in the Constitution that jury trials are the rights. I don't know. It's going to be interesting. So our first we're going to go right into it. Our first response is apparently from Justice Thomas, my homeboy. Me and him hang out all the time.
Wouldn't that be neat?
That would be awesome. I'd love to hang out with Clarence Thomas.
I welcome the court's questions.
Are you suggesting that the exhaustion or your exhaustion argument has historical analogs?
I'm suggesting that this court held in Del Monte Dunes that a 1983 action at law for damages is an action at law for Seventh Amendment purposes. And I think the state has conceded, and we submit as well, that there is no precise historical analog for the specific theory of the affirmative defense in this case. And I think Del Monte Dunes tells you that when that is so, you look to the functional considerations, the divide between the judge and jury, and predominantly factual issues are for the jury as a default rule.
That's hard to argue with. I mean, predominantly factual claims are for the juries to sort. I mean, then it comes into, well, what is exhaustive, right? And what determines if other things have been exhausted, or should anything and everything proceed directly to jury trial? That's a bit steep because everything doesn't proceed directly to jury trial, even in the criminal world.
Yeah.
There's steps. You got to go in, for the arraignment and this and that and this and that. There are several steps before you get to that.
And then there's always like a plea deal too.
Yeah. And then there are plea deals that are done. And so, yeah, maybe eventually you end up at jury trial. But I think the argument is, how is a judge allowed to derail that process along the way? Or, as we're seeing more and more of, arbitration agreements. Arbitrations. Those are look into arbitrations before you sign an arbitration agreement with whatever company you sign up with. Make sure you understand what you're signing. Arbitration agreements are not courts. They are people who have been empowered to make decisions, and they rarely have your interest in mind. Just saying. All right. We jump straight ahead. We just let it play, and we go to Robert's local hero sandwich.
Why isn't it enough for you to get the right to a jury after an exhaustion determination if that determination is non-binding?
Two things. I'm not sure why it would be non-binding. But the second is, in this lawsuit, Mr. Richards got past summary judgment on a theory of unavailability under Ross versus Blake and a First Amendment claim that the Sixth Circuit said stated a prima facie case for First Amendment retaliation. He got to the point where he should have had a jury decide that. The Seventh Amendment can't turn on whether, after dismissal, a pro se plaintiff might be able to file lawsuit 2.0 on some of these claims.
Well, why not? I mean, if the prior determination without a jury is not binding, what exactly has been taken away? If you can proceed to litigate before a jury with respect to exhaustion, what's the great loss? Other time, of course,
other than 5 years
but he's got time on his hands, right?
of effort.
Yeah.
It's no small.
How much time does this guy have? Do you know?
I
Don't
really
know
don't know.
offhand. Okay, that's okay. I think it's a lot.
feat for a litigant.
Yeah.
It's no small feat for a litigant like Mr. Richards, who was representing himself throughout these proceedings until the Sixth Circuit appointed counsel, to even get a case filed and before a court and all the way past summary judgment. So I think that's a significant consideration. But our, second point is that I think, the modern restatement of judgments would say that once an issue is finally decided, the words "without prejudice" are not magic words that mean that nothing has actually been decided. And I don't think the state would take the position that in this hypothetical lawsuit 2.0, Mr. Richards could re-argue the very thwarting facts and allegations that were the basis of both the unavailability claim and the First Amendment claim.
Yeah, this guy Richards, did you look up and see how much time he had or
I
no?
couldn't find it.
That's all right. Okay, so we're going to go into another local hero, Barrett, which horrible disappointment as far as I'm concerned, but this is just me. Okay, launch into Barrett. We got, looks like about 3 minutes.
Yeah.
Till our next little jump. Here we go.
Counsel, can I ask you a question? This is a methodological one. In some ways, this case presents the problem that we've seen in the Second Amendment context, because this is a history and tradition test, but it's one that goes all the way back to Justice Story in like 1812, right? And, in other cases, we've been able to draw analogs based on the cause of action. And I think that's a more or less stable line when you're trying to find a historical analog. Is this more like a common law or an equitable question? This defense thing is a lot harder, right? Especially since there was no really good analog at the time of the founding. So I think what we have now is Congress coming up with something new. And then what do we do in the face of historical uncertainty? And, functional considerations may guide, but I guess what I'm trying to figure out, and this is really just a question, it's true, as you say, that one set of circumstances we could look at in making a judgment about whether this goes to a jury or has to go to a jury if he invokes the Seventh Amendment right is the factual nature of it. Another one, though, is does Congress have some room here to create new defenses that are functioning more as equitable, like these threshold questions? And it seems to me like in Wetmore, the court did, even though jurisdiction was a jury issue in the beginning, to kind of back off a little bit and said, well, a judge has discretion to go one way or another based on the 1875 Act that didn't lock in the form of pleading. So, I guess my question is, in the face of historical uncertainty, how do we weigh what Congress has to say about threshold considerations? Because it is clear that in the PLRA, exhaustion was designed to try to weed out suits.
Okay.
I'm not saying that that's determinative. I'm just trying to figure out how to think about it.
I think I understand the question. I think most of your question is sort of answered by the detailed analysis of the majority opinion and Justice Scalia's concurring opinion, which the majority said that they agreed with in full in Del Monte Dunes. And there, history certainly was the guide and provided the analog, which was a common law, tort claim for damages, was the historical analog that allowed the court to say, no question that a 1983 action for damages is an action at law. And so the question is, what work does the history do on the specific issue question? And I think the court resolved that by simply saying, where we don't have a guide, we look to precedent and then, functional considerations. And the court described those functional considerations as preserving the jury's historic role as the trier of fact.
This would be really, if I was a judge sitting on the Supreme Court, this would be a really hard one. It really would. I think we're going to see some interesting responses on this one. I agree with you. Like you said at the beginning, I don't think we're going to see our standard split. No. I think we're going to see something a little different in this case. All right. We'll jump ahead just a little bit and we're going to go to 5607. And this is apparently Sean's personal friend, Samuel Alito. I'm kidding, by the way. None of us know any of these judges. I'm just being dumb. Here we go.
Along those lines, I want to understand the implications of what you are asking the court to hold. So in Judge Posner's decision in Pavey, I know you think his logic is nonsense. He ticked off a number of other questions that are threshold issues that are not necessarily decided by the jury. Subject matter jurisdiction, personal jurisdiction, abstention, forum nonconvenience, venue. What would be the implications of a decision in your favor here on all of those?
Okay, now that is a fair point, right? There are, like we were talking about earlier, there are aspects of these lawsuits that are handled by judges, by the courts themselves, without the jury element, at least not yet. So this is a really good question. If the court decided in your favor, what are the effects with all these things?
Potentially very little to none.
If there's an overlap between
right.
wouldn't the logic apply there, or why would it not?
It would, Justice Alito. I think the general rule, the rule that is applied by the federal courts almost uniformly, and the state doesn't really take issue with it, is where you have a common factual issue, so you have real intertwinement with the merits. Even so-called matters in abatement or judicial administration get deferred to the jury. And that is because we're preserving the jury's historic role to resolve factual disputes.
I don't know that I don't think we've ever held that, and I don't know that the lower courts say that always has to be done. Well, let me ask you another question about the implications of this. What about other exhaustion requirements that are connected with a claim that may have a 1791 analog? So something that occurred to me, maybe this is completely off base, but it did occur to me. What about exhaustion under Title VII? So that has never been considered to be a jury issue. Now there is a right to a jury trial on a Title VII claim. Congress has extended it, but there's an argument, commentators have made the argument, that the Seventh Amendment would also cover that, because a claim for unlawful termination would have some 1791 analogs. So what about that?
Okay, I got to know what a 1791 analog is. I don't think that's what we're looking for. Let's try.
Or analogics.
Maybe. I think.
Was he referring to the Second Amendment?
I don't think so, but they have mentioned it. Interestingly enough, it has been mentioned a couple of times by Barrett. And so I think, and this is just my interpretation, I think she's saying that, at least her, when she brought up the Second Amendment, is we have to look to the future, right? When they're talking about the Second Amendment, an argument is often made that the founding fathers had no idea that technology would progress the way it's progressed, and that we'd have ARs and AKs and all the things that we have now. Now, that's an argument for another time, but I would urge everyone, oh my goodness, I would urge everyone to look into, I believe it's 26 in the Federalist Papers. It's in the 20s. And it's very, very clear that not only did Gatling guns exist, but people owned cannons. They're in the Federalist Papers. The very people who created our Constitution and Bill of Rights clearly outlay that the population of the United States should have the most powerful weapons, at least, if not better, at least as good, if not better than the military. Clearly outlined, and I know people like to ignore that, but That was the original intention of it. We're going to jump ahead to 1 hour, 23 seconds. If I can get there, we go. That was close. All right. And then we're going to go into Gorsuch. Neil. Good old Neil.
Amicus brief and others have pointed out, even need to go that far. I mean, you've got an amicus brief and others have pointed out there's a long federal policy of background, almost federal common law, or at least an interpretive of the statute to avoid constitutional avoidance concerns, say unless Congress speaks more clearly, we're not going to assume it took away the jury trial right in cases of intertwinement under the PLRA.
I think that's also right. I mean, Congress didn't speak to this issue, and you could hold, consistent with your opinion in Jones versus Bach, that Congress's silence means that the ordinary procedures should apply. And in this case, the ordinary situation is that disputed facts about affirmative defenses that are intertwined with the merits go to a jury.
I mean, is she wrong, though? She makes a compelling argument there, I will say. And in general, because it's pretty darn clear that trials are to be decided by the jury unless the person bringing it or defending themselves would prefer a trial by judge, because that's an option.
When those people aren't doing it for goodwill, though,
right? And that's
the problem. Is
there's a lot of
people
problems
that want to
and
flood.
I noticed they keep talking about PLRA. I thought it was PREA. What is the PLRA exhaustion requirement? I think this is what they're talking about. Oh, Prison Litigation Reform Act exhaustion requirement is a federal law that mandates prisoners must exhaust all available administrative remedies before filing a lawsuit in federal court regarding prison conditions.
Which means they have to go through the prison, right?
Right. Which means they have to file a grievance. They have to talk to their counselor. They have to talk to the staff. They have to do all these things. And to my point earlier, I guarantee you there were rights violated by the nasty ass food they were serving these people and the absolutely abysmal medical care that they were giving these people. Why? Because this shit was contracted out. It's a joke. However, can people just bring random lawsuits? I mean, you and me, we can file a small claims action against pretty much anyone and have our day in court. But it's a little more of a higher bar when you're talking about like suing a company, suing a state for more than small claims. Then all of a sudden you get into discovery and, there has to be some degree of evidence in order to blah, 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 blah. So it's going to be interesting. All right. We're going to go right into Justice Sotomayor again. She talks a lot. I'm just kidding. She has some really, really pointed and excellent questions, although I think her mind is made up.
It's Kavanaugh. I might have made a mistake.
Oh, no, that's my bad. I picked the wrong one. I'm sorry.
Sotomayor's
it is Kavanaugh.
Yeah. Sotomayor's next.
Sotomayor's next. I was looking at the wrong thing. It's Kavanaugh. Here we go.
If we get to functional considerations that Justice Barrett was raising, it does seem to me like you would look at the policy of the PLRA. The court has said to look to statutory policies, and that policy seems quite inconsistent with a jury trial right on the exhaustion question, because the whole idea of exhaustion was to be speedy, to have the prison be able to resolve things quickly. And it seems just, the argument on the other side just seems generally inconsistent with the policy of the PLRA. So you want to respond to that?
Sure.
Okay. Really quickly, I got this figured out. All right. So this entire lawsuit hinges on the current outlines of the PLRA, which is you have to exhaust everything internally before you can sue. What I believe the attorney McGill is saying is that it should be let a jury decide, don't let the prison decide, which the problem they're running into, and this is now I get the questions at the beginning, which is Congress has already kind of laid out how this is supposed to go. What they're arguing is it's unconstitutional or it shouldn't be that way. Much like in the case of the Second Amendment, Congress has created laws, but I think more and more of these laws are about to be found unconstitutional based on the rumblings from the Supreme Court. And then we get into a whole other can of worms. But the important part for this is, can prisons be trusted to figure out whether there's merit to this lawsuit before it goes in front of a jury, or should it bypass the prison system itself and go straight to the legal department? The PLRA was established because they were getting swarmed by lawsuits.
What might happen is, if this is found unconstitutional, maybe they'll create some new courts, which Congress can do just for the prisons.
That's an idea as well.
That's what they might have to do because of all the lawsuits.
Yeah. And so they're talking about courts like these administrative courts for like Social Security determination and stuff like that. So Congress did all of that. Might be something for this. Here we go.
Justice Kavanaugh, 2 points. I mean, the state relies, I think, principally upon a 1966 case called Katchen versus Landy that has some language that sort of suggests that congressional policy can be relevant to functional considerations. I think the court has moved significantly away from that. And after cases like Grand Financiera, I'm not sure about the continuing viability of Katchen versus Landy. But the other thing is that...
What about Markman?
I mean, Del Monte Dunes was an application of Markman itself. And I think that, this case, if you have a spectrum from sort of pure historical facts to legal issues, Markman is sort of on one end, and our case and Del Monte Dunes are on the other. That we're not talking about construing a legal term of art, in a legal instrument.
Okay. Almost done. We got this clip and coming up and one more. Next is Sotomayor. And we got right at a minute. And then Barrett for 2 minutes and we're done. So hang in there. We're almost there. Here we go.
I might have thought that if Congress was thinking about this as requiring the judge to make a determination to supplant the jury trial question, the PLRA does have a list of things that a court has to do without objection. It has to look at the complaint and decide whether any immunities apply, whether a bunch of other things that it requires. Grievance is not one of them.
That's right, Justice Sotomayor, and that was part of the court's holding in Jones when it determined this is an affirmative defense. I mean, to be clear, there are other things that Congress could do but hasn't done to narrow the scope of cases that can get past Rule 56 and require a trial. But once an issue is made, to use the language from TELABS, once a genuine issue of fact is made under whatever the requirements are in the statute, it goes to the jury. And I don't think Congress has anything to say on that.
So on this.
Okay. And our last little clip here comes from Amy Coney Barrett. And we're going to finish up with that and bid you adieu.
Antecedent question of whether you're entitled to the jury trial right in the first place because of the analog, because of the historical considerations, what have you. No circuit has held that right. So we would be kind of treading into new territory that's different. I mean, it goes beyond the QP. It was briefed that way. And let's just assume if you lose on the intertwined question, you could still win if we decided that the defense was entitled to a jury trial regardless. That didn't depend on factual intertwinement. But isn't it the case that that would be striking significantly new ground?
In some sense it would, and in some sense it wouldn't. I think the problem with the current state of the law, frankly, is that the first decisions on this after the PLRA was enacted came about in the early 2000s. I think it was a Ninth Circuit case called Wyatt. And it was before this court decided Jones. And the court just sort of referred to exhaustion as a matter of abatement or a rule of judicial administration without really thinking through what that means. And the courts have not reconsidered those decisions in a meaningful way after Jones.
So true. I'm not saying that they've gotten it right. That's kind of an argument for, hey, they've done this reflexively, or they all followed the first court to answer the question. But we don't have cases where circuit courts or courts of appeals have reflected on this issue and said, here are, the historical analogs and the reasons why it comes within the Seventh Amendment, or here are the functional reasons why it does or it doesn't. We would be doing that for the first time, right?
You would, and I don't think it's that different than what you did in Jones, although there were a couple circuits on the court side. But I think that there's a pretty well-worn path between what you've held in Jones and what we know from Del Monte Dunes and other cases.
Okay. Oh yeah, this one's going to be really, really interesting, I believe. We're going to have to pay close attention to this. Is this the only hearing, or are there going to be more? Is it going to be multi-day?
For this case?
Yeah.
This is the only hearing.
This is the only hearing. This was their opportunity to say everything they had to say, give the justices an opportunity to ask everything they wanted to ask. And we should expect a decision whenever they get to it, right?
My guess is probably midsummer.
Midsummer. Okay.
Probably June or July.
June or July. All right. I think you're probably right. So
I'm not even going to predict on how it's going to go.
No, I have no idea. That's what's really wild. Normally, these Supreme Court cases are pretty easy to predict. It's like, oh yeah, we're going to see your standard, 5-4 or whatever, right?
6-3,
6-3, etc.
But you never know where Roberts and Barrett.
Exactly. Those are squirrely. And did you hear? And just really quick at the end, did you guys hear about this club that Roberts is supposed to be a part of? Some, for lack of a better term, secret club for judges. That, you didn't hear anything about that?
No.
Hold on. Let's see. Really briefly, we're going to wrap it up, but let's see. Okay, so according to this, and I always like to show you guys, this is Google, obviously,
AP.
and AP says posts falsely claim federal judiciary members are in secret clubs. U.S. News and World Report also says it's not true. So according to this post, this isn't really a conspiratorial group as some other posters noted. It's more like a judges and lawyers club for mentorship and networking. Interesting. So here's the actual post. America Ends of Court also includes the radical America hating judges James Boasberg, Barry Howell, etc.
Brown Jackson.
Yeah. So I'm just going to click on this X post. It says here, in a Washington, D.C. townhouse, Chief Justice John Roberts sipped bourbon with Judges James Boasberg, Beryl Howman, Amit Mehta, and Ketanji Brown Jackson. Invite only gathering uncovered, buzzing with whispers of judicial strategy. It says American Ends of Court. I have not heard of that before, but it's something to look into. I don't know. I'll be the first to tell you. I have no idea if there's any fact to that at all. Here's the thing. You used to be able to look at something and use your favorite search engine, and generally you'd get an answer to it. Now you can't trust AP.
No.
I have read some outright lies from AP. And speaking of, we had this other hearing with NPR and PBS that had some very disturbing clips, like straight up disturbing clips that the people who run these organizations believe the way they do. And it explains a hell of a lot.
We'll break that down.
Yeah. We'll get into that. Look, guys, go ahead.
Next week.
Yeah. So we got a couple of shows coming up for you next week. Hopefully, we're looking at potentially Tuesday night and Friday night, right?
Monday and Thursday.
I was wrong on both.
Yeah, I was going to wait.
My calendar is currently in use as a camera. So Monday and Thursday. Thank you, Sean. Monday and Thursday. Set your calendars, and we hope that we will see you guys then if not, catch us when you can. I think that's it,
Yep,
right?
that's it.
All right. Without further ado, God bless you. God bless Indiana, and God bless the United States of America. Hope you have a wonderful evening, and we'll see you again real soon. Bye.